Title of this is Trademark Talk. There's romance there. You may be wondering, what's romantic about trademarks? I kind of fell in love with this area of the law when I was a first-year associate 34 years ago.
Oh, come on.
Seriously, Philadelphia Volunteer Lawyers for the Arts kept sending me pro bono clients. They were artists who had trademark and copyright problems. And 34 years ago, Ballard didn't have any lawyers who practiced in this area. So I had to madly research and learn and scramble to help these clients. And I fell head over heels in love with this area of the law. A few years later, I was talking to a new associate trying to get more recruits. And I was saying, but trademarks are about language and communication. And Arthur McAdon, the head of litigation, was standing there when I said this. And he came up to me and he said, Jamie, you romanticize your work. And I said, no, the romance is there. You just have to open your eyes and see it. And the beauty of this stuff is it's everywhere. We're bombarded by trademarks everywhere we go. So I'm hoping to impart to you some useful concepts today. And I bet you, some of you this weekend will think back. You'll see something on TV or in a mall or somewhere, and you'll think, oh, yeah, that's weak. Or that's strong, or that's great. All right, so we'll see. Where do trademarks come from? We're going to start with Jeff Bezos. Jeff Bezos was born in Albuquerque, New Mexico. Some of you probably noticed, why is this not moving? January 12, 1964. When I look at that date, this dates me, but that's okay. When I look at that date, you know what pops into my head? He was born a few weeks before the Beatles came to America. That's like a watershed event in American culture. Now, Greg Seltzer thinks it was 1965, but I think it was when the Beatles appeared on Ed Sullivan. Anyway, so Jeff Bezos. So he went to Princeton, and I am not... All right, you know what I'm going to do? I'm going to do this. He went to Princeton. He was going to major in physics, but he got really into electrical engineering and computer science. Graduated summa cum laude in 1986. What do you do with those degrees? Those are pretty fancy degrees. Well, he went to Wall Street, and he worked there for a while, 8 years, and ended up working for a hedge fund and among other Wall Street type companies. And then in 1994, he decided he's going to take a trip driving across the whole country. And he's going to think about what he wants to do next. When he gets to the West Coast, he's decided he's going to go into the book business, but without having any stores. No stores, just warehouses and a website. Now, at the time, no one was doing that. It's a little weird, right? So what's he going to call this new business? You know, what do you think of? Internet books, readers online, maybe virtual bookstore, books on the web shop books. There's a lot of things you can come up with. He decides to call it Amazon, okay? And actually, drop a footnote here, Amazon wasn't his first choice. His first choice was Cadabra, as in abracadabra. And he wanted to call it Cadabra, but every time he said it to anybody, they thought he was saying cadaver. So he thought, that's not so good. I'll go to another next on my list. So that was Amazon. All right. Now, if you really think back to 94, no one was selling books over the internet without a bookstore. So think of how you would have reacted to this name back then, Amazon. What does the Amazon River have to do with books? What does it have to do with marketing over the internet? What does it have to do with websites? I mean, really, nothing. It has nothing to do with those things. That's what makes it powerful. Because no one in the book-selling industry needs to use that word. The purpose of a trademark is not to describe your business. Even though everyone in the world, and I've worked with 1 million clients, your first thought is, yeah, it's got to, signify somehow give people an idea of what you're doing. No. It is not to provide information about your business. The purpose of a trademark is to identify your business and distinguish it from the competition. A trademark should mean you and only you. Now we're going to think about Steve Jobs for a minute. He enrolls at Reed College in 1972. He drops out. He moves back home. He spends all day in his parents' garage. One night, Uncle Morty comes over for dinner with Aunt Sylvia. "What are you doing out there in the garage, Stephen?" Morty asks. "Well, I'm working on something, maybe start a computer company." "A computer company? What are you going to call this computer company?" asks Morty. Steve replies, "I think Apple." "Apple? Apple? What kind of name is that?" I don't know, I like it." On the drive home that night, Morty says to Sylvia, "That boy, he doesn't have the brains he was born with." Now, neither of these guys, Jeff Bezos or Steve Jobs, had studied trademark law. But they instinctively sense something very important. A trademark does not describe. A trademark signifies. And what it signifies is you and only you. That is, if you do it right. So let's look at what is a trademark, what can function as a trademark. Okay. Trademark is anything. It can be a blob, it can be a word, it can be a string of words, a phrase, it can be a symbol, a little graphic design, a picture, anything that identifies the source of products or services and distinguishes it from the competition. Yeah.
Can it not even be a color in some instance?
There are situations in which colors have been adopted as a trademark.
Insulation, I think, maybe?
Yes. Yep, that's exactly right.
Yeah.
Yeah, it's a little tricky, but it is done sometimes and has been done successfully. We're going to talk about color. So words, Coke, Ralph Lauren, it can be a phrase, diamond is forever, or how about melts in your mouth, not in your hand. Did they still say that? I remember that from my childhood. I don't remember it recently. Yeah. Can be images. Everybody knows that Nike swoosh. We're going to talk about that a little later. The Twitter bird. How about the Olympic rings, which have super high protection under U.S. law? Here's a bunch more. The Apple. McDonald's is crazy with its branding, amazing branding. FedEx, Starbucks, you've seen that everywhere. HP and Dell, Coke, of course, and Bank of America. Here's more Nike, KFC. Who knew? Who here knew? I didn't know that NASA had a logo. I didn't know that. I was so freaked out by that. I started looking up all these branches of government. The FTC has a logo. It's boring, though. And even the IRS has a logo. But they're not as glamorous as that NASA logo. That is incredible. Chanel, Target. Target is unbelievable with their branding. And Adidas, Starbucks. Starbucks already. Okay. You can combine words and numbers. 501 Jean, Chanel number 5. Everybody knows V8 Juice and Century 21. I wonder if they're going to change it to Century 22. You know, we're catching up to them already. Trademarks can be shapes. Everybody knows that distinctive Coke bottle with the fluting and the curves. I did not know until I started researching this that the shape of the cross pen is claimed as a trademark. A little teeny thing. Everybody knows those Toblerone bars. Triangular type. Oh, I have a good story about this. So Hershey's apparently has even gotten official trademark protection for this shape thing, which I always think of as so boring. Like, I don't even like Hershey bars. I don't think they're very good chocolate. But it's the particular combination of recessed rectangles with a raised border in the Hershey bar that was not functional and therefore could be protected as a trademark. The functional thing is important. If something is functional, then it has to remain in the common pool of vocabulary for all competitors to use. If you're going to claim it as a trademark, it can't have a functional aspect. There's a little bit of functionality to those lines, but I just finished reading a book by Robert Hilburn. He was the music critic for the Los Angeles Times, and it was about his getting to know a whole bunch of different musicians, Bob Dylan, Bono, John Lennon. Anyway, in the chapter about John Lennon, I have to tell you this story. It relates to this. He describes being in the studio with John and Yoko. John had returned from L.A. He'd slimmed down. Yoko put him on a diet. He slimmed down, and they were recording Double Fantasy. This is actually not too long before he was killed. And everything was great. John was in a great mood. They were making all this great music. Robert Hilburn's hanging out. And then he noticed John kept leaving the room. Like, periodically, he'd leave the room and go into this other room. And it was like the room on the way to the restroom, but it was, and Hilburn went in, and Lennon was up by a cabinet, and he quickly pushed something in the cabinet, and Hilburn thought, oh God, he's back using cocaine again. So another time he went in, and John was doing the same thing, and he said, Robert, come over here, you want some? And Hilburn thought, oh God, I really don't want any cocaine. And he went over, and it was a big Hershey bar. And he said, don't tell Yoko. Yoko had put him on a macrobiotic diet. He wasn't allowed to have chocolate. So I think, well, Hershey bars, they're so humdrum. But John Lennon was eating one. Anyway, forgive my excited outburst. Trademarks can be shapes. So when you look at this, you think, well, yeah, maybe, you know, that bottle's a little bit unusual shape, and maybe the color. But you know what? It's not the shape of the bottle, and it's not the color. Here's the official part of the trademark registration for this. Color is not claimed as a feature of the mark. The mark consists of 3 free-form wax neck seals on top of one another, which have irregular bases, forming irregular tendrils extending down the neck of the bottle. The representation of a bottle shown in dashed lining forms no part of the mark, merely shows the position of the bottle in relation to the mark. So it's those wax drippings. So I don't know, I'm going to have to look for that next time I go to the liquor store. I wasn't aware that that was how you find something. Colors. So trademarks can be colors. It's actually, I think it's sometimes a little scary, sometimes not, but sometimes it is. So here's orange. Home Depot loves orange, and they got a registration claiming color for this line, and they describe it, an orange stripe located around the perimeter of the exterior of the one-story buildings in which the applicant renders its retail home improvement services. Dotted lines are merely representative of the shape of the exterior of the building to which the trade dress is applied, and it's intended to show the position of the mark on the building is not part of the mark. So Home Depot is really into orange, and you've no doubt noticed that when you go there. Owens Corning, pink insulation. There's no reason why insulation needs to be pink, and that's why they get to be the only ones making pink insulation. The thing is, my brain keeps thinking, well, but we like competition in the United States, and what if there were 15 different companies making insulation, each one had its own color? Aren't we going to run out of colors? But I guess it hasn't happened yet, so maybe I shouldn't worry. Maybe we'll get into striped insulation. I don't know. Louboutin and the Red Soul. Some of you, I'm sure, know who Christian Louboutin is. Some of you may not really be up on him. I was reading last night, Danielle Steele has 6,000 pairs of Louboutin shoes, which is saying something given that they range from $750 to $1,500 a pair. He is a fancy fashion designer, and he started making all of his shoes with bright red soles. Bright red. And he got into a tussle with Yves Saint Laurent, who wanted to make shoes with a bright red sole. Not all of his shoes, though, but I think he just wanted to make some. And Louboutin sued and won, right? Mm-hmm. And this is where the doctrine of aesthetic functionality comes in. I mentioned functionality before. If there's a reason why you really need to be able to do something to compete in a particular product range, it's really hard to claim that as a trademark. Aesthetic functionality has to do with things in the fashion world. There isn't that much. There aren't patents that much. There aren't that many, unique inventions. But there are colors and there are patterns. And if there's some aesthetic reason why something has to be available to everyone, then it would be considered aesthetically functional. Am I saying that right, Andrea?
Yep, that sounds right.
Yeah, she's the fashion expert. I'm really not, but you are. But anyway, so for the moment, Louboutin is the only one who can make bright red soles on his shoes. We all know about Tiffany and the Tiffany Blue color, which dates back to 1845. Oh, no, it doesn't. It's a little bit later than that, but it dates back pretty darn far. I looked at the Tiffany website yesterday, and I was surprised. It doesn't feature that color in a dominant way. The website had a lot of pewter, and here and there I'd see a little thin line of the turquoise, but it was not what I was expecting. I was expecting to see a lot more of it. So maybe they're getting a little beyond that. The boxes are still all that color.
Are they taking a risk in doing that?
By using it less?
Yeah.
I don't think so. As long as they're using it consistently, it's all their bags, all their boxes. There's probably a number of other things that are that color. I don't think it's that bad.
I don't shop there.
Downplay it a little. Okay, Caterpillar yellow. Everybody knows what that equipment looks like, and you can recognize it immediately. I still worry a little bit about us depleting colors, but maybe when you have a color trademark, you specify the Pantone color, I think. And so maybe if you get a couple spaces away from it, I don't know. We'll see. We'll see what happens. There haven't been a lot of problems with that. UPS brown, that's been their color forever. It kind of blows my mind to think that back in the 1920s, that color was the epitome of luxury. That's wild. Trademarks can also be sounds. As you all know, the chimes from NBC, I think this is supposed to work. No, wait, let's see. So, yeah, kind of cool. They've got that registered. The mark comprises a sequence of chime-like musical notes which are in the key of C and sound G, B, C, the G being the one just below middle C and the C being middle C. Wow. Okay. Then we've got the lion. Yeah, that's cool. That's been around forever. Then we've got a company that went maybe a little far. Harley Davidson tried to register as a trademark the sound of its motorcycles. And they filed an application. They claimed that their mark consists of the exhaust sound of the motorcycles produced by V-twin common crankpin motorcycle engines when the motorcycles are in use. Their competitors went completely nuts, and they claimed that they all made the same sound, and it was not distinctive, and it was functional. And after 6 years of litigation, Harley gave up. So, yeah, too bad. Scents. In some instances, a scent has been registered as a trademark. And I say registered, I should mention here and want to emphasize that trademarks in the United States are protected under the common law. So that means as soon as you start using a mark, you start to have enforceable rights in it. You're not required to get a federal trademark registration or a state trademark registration. In this instance, the person who wanted to make this sewing thread and embroidery yarn that had a scent did get a federal trademark registration for the scent. High impact, fresh floral fragrance reminiscent of plumeria blossoms? Does anybody know what plumeria smells like? I don't. Yeah. And the person who got this registration, she had it for 5 years, and then in the 5th year, you're required to make another filing saying, yes, I'm still using the trademark. Here's a sample showing how I'm using it. She didn't make that filing, so it got canceled. So it may be that, she went out of business or stopped using the scent. People didn't like it. I don't know. Domain names can be trademarks. Now, a domain name, as you know, is an internet address. So they're a functional thing. Not all domain names are serving as a trademark. You really have to go to the website and look at how it's used. I'm not sure Amazon.com, we had that on there originally, and Amazon, when you go to Amazon now, you see Amazon. Mm-hmm. But there may be other instances where it's being used in a bold and notable way. Priceline.com, I think, is, and Yahoo.com. I think there's a trend away from that, though. Don't you think?
I think so.
I think it's moving away from that, yeah. So, and as you know, domain names are unique. Each one is just one domain name. Trademarks can also be the appearance of a building. So the Rock and Roll Hall of Fame, I don't know how many of you have been there, is pretty distinctive looking. The Guggenheim, obviously, very distinctive. McDonald's, not as distinctive. I'm not sure what they claim on that. And then the Wrigley Building in Chicago. Now, in 1996, I think, Congress passed the Architectural Works Protection Act. Is that the right year? Can't remember. Maybe it was 1990. But anyway, copyright now protects the design of buildings as well. So these building owners have two kinds of protection. Chevron spanner design. Distinctive three-dimensional hexagonal shape and attention-grabbing size sets it apart from the spanner designs at other gas stations that are smaller and comprise simple, nondescript ovals or rectangles that are the same or very similar to each other. So you see these are pretty technical descriptions of these trademarks. Okay, we're going to talk a little bit about the spectrum of distinctiveness. It sounds kind of like something in Star Wars. I like it. It sounds ominous, right? The spectrum of distinctiveness. So not all trademarks are created equal. The courts and the trademark office classify them according to their strength. They can be very powerful at one end of the spectrum. They can be unbelievably weak at the other end. The strongest trademarks, I've kind of hinted at this already, are those that have no meaning, or certainly no meaning in relation to the product that they're being used for. The more descriptive a mark is, the weaker it gets, because the more you get into that realm where you're using words that have to remain in the common vocabulary, where everybody in your competitive industry have to be able to use them. So Apple, we gave that example already. Apple for computers. Apples have nothing to do with computers. That's a strong mark, strong from the day it was put into use. Similarly, Amazon, the Amazon River has nothing to do with selling books or anything else over the internet. Those marks are called arbitrary, and they're at the far end, strong end of the spectrum. The other category of marks that are super strong are made-up marks, coined marks. They're just words that are not words in the English language. Exxon is a great example. Playtex. How about Hedgeye? That's a client of ours. I love that word. I didn't help them with it. I wish I had. It's their name. They're a financial services company formed by guys who had worked at a hedge fund. And they give a lot of, advice to people on investments. But how cool, Hedgeye. I have a client who says a trademark should be fun to say. And I think she's right. I think the coolest trademarks are the ones that trip off your tongue. I really do. And I have clients who think that's not dignified, but I still think they stick in your head. They go very deep. So Hedgeye, wow. Here are some other really strong ones. Xerox. X's are big. Kodak. Exxon. Clorox. eBay. I always wonder where eBay came from. Electronic. I don't know. I'm thinking.
Maybe the east side of the bay.
Yeah, that's what. Yeah, probably. Reebok. Now, moving further down the spectrum, we're getting a little weaker now. There's a category of marks called suggestive marks. They're not racy. They're marks that they just kind of suggest a quality. They don't describe. So they stop short of description. And with a leap of the imagination, you can make a connection. So two of my favorite suggestive marks of all time are marks for raincoats. One is London fog. Think about that. So London fog doesn't describe the product. It doesn't describe a characteristic of the product. It doesn't describe the user of the product. Those are the things that make a mark descriptive. But obviously, you hear London fog and raincoats, you make that connection, right? It's meaningful. So that's one. And the other one, Carol Cohen had a mark for a while, drizzle, for raincoats. Same thing. Doesn't describe, just makes that connection. Some clients really, really like suggestive marks so much better than arbitrary ones or coined ones. And I can understand why. They're hard to come up with, though. They're a lot harder. You have to be really creative. How about this, Nike? Now, when you see lists of strong trademarks, suggestive, etc., you often see Nike on the coined list, like a made-up word. It doesn't exist in the English language. It's just a made-up, coined word. But guess what? Nike is the name of the Greek god of victory. So I am certain, I don't know this for sure, but I'm certain the two guys who started the company, they had to have been thinking of that Greek god, right? So I think this is suggestive, right? They're making a company that's going to make athletic equipment. I mean, athletic clothes and stuff. I was reading about Nike the other day, and I went on Wikipedia, and I typed in Nike, and Wikipedia has that brand, that disambiguation page where they have a whole bunch of things, and you click on the one you want. So on the disambiguation page, the first Nike was the Greek god of victory. The second Nike said Nike Inc., brand management company for athletic clothes. And I thought, oh my God, it's like brands are taking over the world. It's identified as a brand management company, not a company that makes, stretchy capri pants or sneakers with the swoosh.
That may be because they're using that for tax purposes.
Maybe, I don't know.
They keep the trademarks separate and then they license it to the manufacturing.
Maybe that's right, Richard. That might be it. Just like, wow. Okay, now, we're moving down this...
Is Under Armour the same thing?
I don't know.
It's suggestive? Do you know Under Armour?
Yeah, oh yeah.
Would you call that suggestive?
Oh, suggestive.
Yeah.
Under Armour. Yeah.
Oh, yeah.
I would. Yeah, it's clever. Clever suggestive, yep. So moving down, now we're deteriorating into descriptive marks. This is where people sort of automatically go when they're starting a business, and you really want to keep them away from it, because it's a nightmare to have a descriptive mark. It's very hard to enforce your rights. You've got all sorts of people competing with you with similar names. It's hard for people to remember and to figure out who's you versus 3 or 4 competitors. So they're very, very weak. TV Guide is descriptive. Now, TV Guide, what they have is a logo, with that red square. And they kind of hang on by the skin of their teeth with that trademark. At this point, it does have secondary meaning. And secondary meaning means when you see the words, there's first the dictionary meaning. You know what those words mean in the dictionary. And then the secondary meaning is you say, oh yeah, no, those are those guys who publish that little thing that I buy at the supermarket and blah, blah, blah. It's like it's them. That's secondary meaning. That means there are enforceable rights in the descriptive mark. But it's not easy to enforce. And then at the far end, at the very bottom of the spectrum, you've got generic marks, which really aren't marks at all. They're category designators, so they're not protectable, like yo-yo. That's just that wooden toy with a string in the middle, zipper, aspirin, escalator. Here's a whole bunch more, cellophane, cola, cornflakes. Anyone can use those words. Anyone making that product can use those words. Actually, you could take the word linoleum and turn it into a trademark for something completely unrelated. It seems like it would be a good name for a rock band.
That's not
Right? Linoleum? Yeah. So, okay. Now, we call this, when sometimes a trademark starts out as a trademark, and then it becomes so successful, the product is so successful, that it loses its trademark significance. We call that genericide. So that happened, for example, to Bayer. They brought out something called aspirin, which is their trademark for acetyl salicylic acid. But they didn't take very good care of the trademark. And everybody just said, oh yeah, get some aspirin, get some aspirin, not get some Bayer aspirin or get some aspirin brand acetyl salicylic acid. It's not surprising, it's hard to say. And pretty soon, aspirin just became the category name for that compound. The same thing happened with Otis, which was the first company to sell a moving staircase. They called it escalator, and before you knew it, everyone was calling moving staircases manufactured by anyone at all an escalator. And so it's not a trademark anymore because it can't designate a single source. This is why you hear you hear ads, Kleenex brand facial tissues. It sounds so prissy. But that's why they say that. They are Kimberly-Clark is constantly doing that. And Jell-O brand gelatin. Because people say, yeah, I want some Jell-O. Yep, get some Jell-O. And they don't really mean Jell-O coming from that one company. They just mean gelatin. And the same thing with Kleenex. Give me a Kleenex. Give me a Kleenex. You're supposed to say, give me a tissue. Mm-hmm. Remember that. And believe it or not, thermos is a trademark. I researched this the other day. I was thinking, that's got to just mean one of those insulated containers. Nope. There is a company called Thermos. They have a trademark for thermos. And when you look on their website, they say thermos, food and beverage containers. That's pretty close to genericide, I think. I think they're kind of walking the edge there.
Sheetrock. I believe that's still a trademark of U.S. Gypsum because they get really excited when you call.
Sheetrock?
Yeah, wallboard.
Oh, really?
You need to call it wallboard.
Huh?
Or sheetrock brand.
Yeah.
Wallboard. I think that's.
So there, it's
maybe almost there.
It's you got to be when you get famous. You got to be really, really careful. We'll talk a little bit about trade names, trademarks, service marks, and related things. You probably know trademarks are the names of companies. Trade names are the names of companies. Trademarks identify products. And a trademark has to be affixed to the goods. It has to be or on the packaging or on the labels or on a display closely associated with the product. There's this idea of something being tangible and something being connected to it. Service marks are for services, and obviously a service is intangible in a lot of ways, so you don't really have that affixation requirement. You typically see service marks being used on web pages, signage, advertising, brochures, things like that. It's funny, the financial service industry, they drive me nuts because they start talking about all their products. And I, thinking like a trademark lawyer, I'm thinking, okay, what's the tangible product? But all of the financial services stuff is a service, even though they use the terminology product a lot. Here's an example. Domino's, the Domino's pizza business is run by a company called Domino's. So it's a trade name. Here it's a service mark because it's a place you can go in and out of and get food. And it's also, because it appears on the boxes, a trademark. So it's a trademark for the pizza. It's a service mark for the services, the food retail services. And then it's a trade name for the name of the company that renders those services and sells those products. all names and marks are protected under the common law. I may have said that already. And this is another thing to keep in mind. Any name or mark can infringe on another name or mark. It doesn't matter if one's a name for a product, one's a name for a service, one's a name for a company. If they're in a business that's close enough, any one of those things can infringe on any other. The distinctions don't matter. There's also something called a collective mark, so it would be the name of a group. Typically, things like union names are collective marks, the ILGWU, which I think merged with another organization a few years ago, and it doesn't exist anymore, but I remember it. The AFL-CIO, obviously. Then there are things called certification marks. You all know that wool certification mark. It means when you see that on a tag, it means this garment is 100% wool. It's not a mark of the person who makes the garment. It's an independent organization that does certification services, and the maker of the product is allowed to use that mark if the garment is 100% wool. Underwriters Laboratories, they certify safety and good housekeeping. I'm not sure what they certify, maybe just that things are made in a good housekeeping, good kind of way. There's a website noted on that logo, and you can go to the website and get more info on what exactly that means. And Vidalia, is anyone here a big onion person? You are?
Yeah.
Well, then you know what Vidalia means. Apparently, there's something called the Georgia Vidalia Onion Act of 1986.
I can tell
Bill
you,
knows?
I can tell you not from Georgia, Vidalia.
Oh, Vidalia. Oh, I'm sorry. So tell us about them.
That's funny.
Well, it's an onion that meets this criteria. It has to be from a particular plant and grown only in certain counties within Georgia that have a particular soil that ends up with an onion that is sweet. So you can eat the onion raw, and it wouldn't give you tears. And so the Vidalia onion is a very important food product coming out of Georgia. And they do a lot of enforcement because a lot of places, a lot of people sell Vidalia type onions and Vidalia type plants. So you can plant this and it'll grow into be a sweet onion. But it has to be grown. It has to follow that. That's a state statute. So it's probably one of the few food products that is covered by a state statute. But it has to, anyway. So our firm registered that, so that's why I'm very familiar with it, and also to help you with Vidalia.
Well, I'll try to remember how to pronounce it. Have you ever had one?
Oh, yes. They're delicious.
Can you buy them in the supermarket?
Oh, yes. Yeah.
And they must be labeled Vidalia.
Right.
I mean, there's a limited window when they're available.
Right. And it has to bear a little mark. They have a sticker on them, as most onions do, but they'll be from Peru, which are sweet as well, but they're not Vidalia. So it has to say Vidalia on it.
And it's not connected with a particular producer. But
No, there are several farmers out there, but they're all certified by the state to allow their crop to be called Vidalia.
Wow.
So who knew? You can drop this at a cocktail party, and never be invited back.
Right.
But,
I want to try one. Maybe I've had them and I didn't know it. Okay. So we talked about trade name of the business. And it's funny, trademarks and service marks can be registered with the Patent and Trademark Office. Company names cannot be. But as a practical matter, when you look at a client's operations overall and their marketing and their website and everything, you almost always find the company name being used in a trademark or service mark sense, so you end up being able to register it. So when you're setting up a corporation for a client or a corporation or other entity, there are two questions you have to ask. First, obviously, you figure out what state you're going to incorporate in or set up in, and you got to find out if the name's available. A lot of times people think it's available, and that means I'm fine. And they can be shocked. A client may have already done that. They come to you, and they're shocked when you say, well, that's not enough, because you could get sued for trademark infringement. They say, what do you mean? I've got this thing from the state of Montana that says I'm legal, you know? Well, you do. Insofar as Montana's concerned, you can set up a company in that name, but it doesn't help you one bit if you get sued for trademark infringement. So the critical thing, you've got to do that, you find out if it's available, and then you really need to do a search. I mean, it really like a classic trademark search. And don't get hung up on trademark, service mark, trade name. We just call it a trademark search. You tell the search company what the name is that you want to use and what you want to use it for. And then they do a search that's with that in mind. And they search the trademark register, they search all kinds of common law databases, they search domain name stuff, they search far and wide. If you're just in the U.S., they do the U.S. If you want to go beyond that, you can get international searches. But that is really important, because somebody could have federally registered and be using in one part of the country a mark that is very close to the name you've set up with in a similar business. If it's already federally registered, even if they're in a different part of the country, it holds the whole country for their eventual expansion. And when they start to get towards Montana, they knock on your door and say, hey, I've got this federal trademark registration, which predates when you set up your company. You got to change your name. And clients, I've met clients at this stage, and they say, what? Montana gave me this. I mean, I'm fine, right? No, you're really not fine. I mean, unless you're in a different business. But if you're in the same business and they're rolling out and you don't have any way of invalidating their federal trademark registration, you may have a problem. So whenever you're helping a client get started, really, 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 you need to do a trademark search. Okay, so let's talk a little bit about choosing a name for a product or service. There are two key questions. Can this, whatever it is, logo, words, phrase, can it function as a mark? Can it be an indication of source? And we talked a little bit about that. Things that are arbitrary or coined or meaningless, they can generally function as marks. Things that describe what you're doing is really hard. Can it be registered? Registration is not required, as I mentioned, but there are advantages to getting a federal registration. Let's take the word, for example, glittering. Kind of a cool word. So, I like glittering. I want to use it. Well, let's think about what you want to use it for. You have to think about context. You don't own a name in the abstract. You want to get rights in it for the thing you want to use it for. Let's say you wanted to start a diamond business. Well, glittering is probably merely descriptive for diamonds. Maybe you want to start a party planning business. I think it's suggestive for party planning. Or you're into chainsaws. Or maybe all three. But it's arbitrary for chainsaws, I think. So it gets stronger as you go down there. Again, the search is incredibly important. Are you going to get sued? You got to look and see what else is out there, and it's a big landscape. Since you're not required to register a trademark, you want a search that gets into a lot of common law databases, because there could be somebody out there, maybe they're not in your own backyard, but they could be out there. They could have a thriving business using a trademark that's almost the same as yours, and that's going to be a problem if you want nationwide rights. It also, the searches, the comprehensive searches, help you figure out how easy or hard it is going to be for you to enforce your rights, how wide your rights are going to go, and how likely you are to be successful in trying to get a federal trademark registration. Lots of times you start with a knockout search. That's something one of our paralegals can do. You just look at the trademark office registrations and abandoned applications and canceled registrations. current, canceled, and then abandoned applications. And then the next step is to order a full comprehensive search from an outside search vendor. We have a couple that we work with. And that is, as I mentioned, much more comprehensive. You could find something that's abandoned or canceled, and the mark could still be in use. So you got to go beyond what you see. I mean, there's a little bit of analysis involved in these trademark searches. We also have investigators that we use when we want to find out if a mark is still in use. You can't always tell just by going on the internet. So we will order an in-use investigation from one of these outfits, and those can be very, very helpful. Sometimes they even do, they impersonate people and they call up the company and ask a lot of questions. I'm sure they're very careful not to do anything illegal, but those can be really good. So, as I mentioned, registration is not required. Common law rights can be enforced. If your trademark is unregistered and you really want to be sure that everybody knows you claim it as a trademark, you can use those superscribed letters TM or SM. You don't have to. What makes a trademark is how it's used. You can always drop a footnote also at the bottom of your brochure that says this is a trademark of XYZ Corporation. So let's talk a little bit about federal registrations. You can file a trademark application on one of two bases. You either file it on the basis of actual use, you're already using the mark, or you can file it on the basis of your intention to use the mark in the future. You can file an intent to use application. It helps you reserve a mark effectively. And you don't get the registration until actual use begins. But when it begins, it dates back to the date you filed. So the ITU procedure is a really, really helpful thing, really good thing. If you file on the basis of actual use, that means you have shipped your product across a state line with the mark on it or on the packaging. It doesn't have to be a big shipment, but it has to be a bona fide shipment. Or if it's a service, you have advertise your service across state lines. You want to file as soon as possible. I mentioned that your rights go back to your filing date. When you get the registration, obviously you want to use that R in a circle symbol, which you've seen everywhere. Some people who don't like to use that like to drop a footnote and just say registered in the Patent and Trademark Office, or an abbreviation for that, which is shown up there. Using the R in a circle helps prevent anyone from arguing that they had no idea your mark is federally registered, and that can be a factor in how much damages you get if you ever have to sue anybody for trademark infringement. A federally registered trademark becomes incontestable after 5 years. That means no one can challenge it on the ground that they started using their mark before you started using yours. It can be challenged if you committed fraud in getting the registration, but it can't be challenged on the basis of prior rights. You get a registration, you renew it every 10 years as long as you're still using it. You can't have a registration for something you're not using. And there's also, I mentioned earlier, during that first 10-year period, there's a 5-year marker. In the first 10-year period, at the 5th year, you have to make a filing saying, I'm still using the mark. And you have to send in a sample showing how it's used. The federal registration reserves the whole country for your eventual expansion with the mark. So it's especially important if you've got a small business, but you've got ambition, and you think you want to expand. And even if you don't know, even if it's like, we're just small, I don't know. But you could meet somebody who wants to expand it. A trademark is going to be a lot more valuable in any corporate transaction when it's federally registered. And in many corporate transactions, the single most valuable asset being transferred is the trademark. So it really is a valuable asset. Oh, wait, did I skip something here? Yeah, okay, and you can record, if you've registered, then you can get customs to help you with stopping counterfeits, which can be good. Application, it's pretty straightforward, although I really don't encourage clients to do them on their own because you can make some mistakes that you can't fix. You have to file all over again. So, but basically you identify the mark, who the owner is, whether the mark's in use yet. If it is in use, you have to send in samples. And then you have to come up with a description of the products or services, what your business is, and the international class that they belong in. Now, the Trademark Office has classified all of human endeavor, you'll be happy to know, into 45 classes. Who knew? Everything falls in one of these 45 classes. And you can scan through these very quickly. Class 9 has gotten to be a very big class for computers and software and all that electronic stuff. Class 1 is chemicals. And then later on in the list, you've got all the service classes, starting with, I guess, 35. So whatever you're doing, it falls in one of these classes, or maybe more than one. And there's a per-class filing fee with the Trademark Office. That's probably why they have the class, part of why they have. Also, it makes it easier to do some searching. Then, after you file the application, the examiner looks at it and does some things, assesses whether the mark's distinctive. He thinks about that spectrum of distinctiveness. Is it descriptive? Is it generic? Or is it really something that can serve as a trademark? Goes through the Trademark Office records to see if there's any registered mark that is confusingly similar or pending, any mark that was filed before you that's similar, for a product or service similar enough that people could be confused. If there are any issues with your application, and there often are issues of one sort or another, maybe a question about the wording of your ID, they issue something called an office action, and you have 6 months to respond. And then once you get it approved, it gets published for opposition, and that's in a weekly publication from the Trademark Office. Is it weekly or monthly?
It's weekly.
Weekly publication of the Trademark Office called the Official Gazette. At that point, your mark is announced to the outside world, and anyone who thinks they're going to be damaged by the issuance of a registration to you has the opportunity to start an opposition action or request an extension of time. An opposition is a piece of litigation in the Trademark Trial and Appeal Board. It culminates, it's similar to litigation in court. There are depositions and document discovery and things of that sort, motions. But it culminates not in a live trial, but in the submission of briefing to the Trademark Trial and Appeal Board. Okay. Infringement. Talk very briefly about infringement. So if you're trying to figure out whether your mark is being infringed, the critical question, and this is the question that every court is going to think about, is there a likelihood of confusion? And the way they characterize it is as to source, sponsorship, affiliation, or approval among the people who buy your product, the people who buy your product and this other company's products. Is anyone who sees your thing and then sees the other thing going to think they're coming from the same source? If the answer is yes, if it's likely to be confusing, then it's infringement. Confusion is the quintessence of infringement. You don't have to show actual confusion necessarily. Yeah?
Does it have to be purchasers? If it was a free service, would it?
Okay, it doesn't have to be purchasers.
Users.
The consumers, whoever your audience is.
Is there a reason, the equivalent of a reasonable person standard for that, or what?
There's a lot of different ways to prove it, but yeah, I think we would posit a reasonable, yeah. So you look at, we call it the sight, sound, and meaning trilogy. You look at what are the marks, if you're comparing two trademarks, what do they look like? What do they, how do they hit your eye? Then we think about what do they sound like? When you say them out loud, how do they sound? Do they sound similar? And then you look at meaning, connotation. What do they connote? They may look somewhat similar, but sound completely different. They may have very different connotations. And then after you consider that, you think about the products and services involved. You think about how they're sold, what the trade channels are. You also think about how strong is the plaintiff's mark. Are there a lot of other people using somewhat similar marks in this industry? This gets back to why, Steve Jobs was so brilliant to call his company Apple. There's never going to be anybody using the word Apple for computers. And if there was, he could shut them down immediately. There's no need for that. If he called his company Rapid Computing, you picture the landscape. There'd be all kinds of people using the word computing this, computing that, word rapid, Mike, rapidly, rapid, what. It's just not that, it's blurry. So the strength of the plaintiff's mark is an important factor. You also look at whether there's any actual confusion. If you have actual confusion, people coming to you to buy products from the other company, that's great evidence, very strong evidence. You look at intent. Did the defendant adopt your mark deliberately because you were doing really well, you were starting to get good press, and he kind of wanted to ride on your coattails? Or is it just somebody in another part of the country who never heard of you? If you have a federal trademark registration, that puts everyone on notice, constructive notice of your mark and your rights in your mark. That's another reason why it's a good idea to get a federal registration. Courts will look at how close the goods are in the retail marketplace, whether a consumer is likely to encounter them in the same store or in the same shopping expedition. How careful are consumers when they buy these things? Degree of care is a very important factor. And then how likely are these product lines to expand? So there's a lot of things to think about with infringement. Domino's Sugar came into being before Domino's Pizza, and Domino's Sugar did try to stop Domino's Pizza, not right after they started. I think they coexisted for a little while, and the courts ultimately concluded on appeal that there wasn't a likelihood of confusion. I think in part because the logos look quite different, and in part because the circumstances in which you buy Domino's Sugar are very different from the circumstances in which you order a Domino's pizza or walk into a Domino's shop to get a pizza. And obviously there are differences between sugar and pizza. But you could imagine the sugar people saying, well, wait a second, they're both foods, right? But the court drew a finer line.
I think it was Apple Records, too.
Huh?
Apple Records.
Oh, Apple, well, yeah, what happened with that, though? I don't even know. So the Beatles started Apple Records. And then, Apple Computer started. And at the time, they were really far apart. Nobody really saw the future where Apple would start having a music thing, and they have a music thing, right?
I don't think they had iTunes at first, but...
Yeah, no, they do.
That's probably why they called it iTunes and not
Right.
Apple
That
Music.
might be why. Mm-hmm. But I don't know that Apple Records still exists.
I'm not sure.
I don't think it does. Anybody know? God, I'm ashamed of myself that I don't know that. I'm supposed to be a Beatlemaniac. Okay, then we have another example. We have all these shoe litigations. And they're kind of crazy. When I look at these, I know Nike owns Chuck Taylor, Converse, the Converse Chuck Taylor brand. But I always think about, here's another example. I always think about that Nike swoosh and how distinctive it is. And then you compare that with sort of sneakers with a line, and a couple stripes. Those things they're like sans affaire. They're just part of the athletic world. And I don't know how anybody can really get exclusive rights. Now, Adidas sued Sears 6 months ago. And this kind of stuff has been going on for years. Companies like Walmart and Sears, they try to make cheap knockoff sneakers. They want to make them look as close as they can to one of the more premium brand sneakers, but stop short of infringing. 6 months ago, Adidas sued Sears over this 3-stripe trademark thing. And a week ago, they the two parties just dismissed the case. So they must have reached some kind of accommodation. I haven't been able to find any news about the settlement, what transpired. But it's just an example of why when you choose a trademark, you really want something that really, really, really is unique. That Nike swoosh, you don't see litigation over that. And I don't think anybody could use that. But stripes on athletic clothes, I mean, come on, they're all over the place. I'm sure Adidas would be disgusted with me for saying that, and this kind of stuff too. A lot of these cases end up settling. But you spend a lot of money on litigation like that. American Beverage had this fruit juice container. It was a certain particular shape, and they got into litigation with Little Sport, which was a little bit similar. Oh, American Beverage Florida Fruit Juices. Bill, do you remember who won this case?
No.
I don't either. Yeah. But it's sort of really, I bet you there's a lot of bottles like that on the market now. A lot. They don't have to be exactly like a barrel. The trademark is very specific. It's exactly that barrel shape. It doesn't go far enough to stop other kinds of little short bottles. That would be crazy, right? Okay, diamond window on e-cigarettes. So Marlboro got really mad at Pax Labs about this new product and sent them a nasty letter. And Pax Labs filed a declaratory judgment action against Marlboro. They weren't gonna lie down for that letter, and they argued quite a bit in the court about whether there's a utilitarian function to that diamond window, how close or how not close these roof-shaped designs were, and the amount of time consumers spend when they're buying an e-cigarette. How much time do they spend looking at the packaging? Would they distinguish? Would they think that Philip Morris had started making these e-cigarettes that Pax Labs was doing? So, but then what happened? Case settled. So we don't know what a court would conclude.
They still use the diamond.
Yeah, they're still using it. Yeah. AstraZeneca launched Nexium on the left, and the generic drug company, Dr. Reddy, was going to launch the generic brand, and this is what they chose as trade dress. AstraZeneca sued them, and I believe it won. So they can't sell the generic brand in purple.
Is there any defense there for the fact that it might aid pharmacists to know that similar products, even though?
Well, there's a lot of.
You don't want the pharmacist reaching for not the generic of what you're supposed to be getting, and
Yeah.
But you wouldn't want a pharmacist.
You don't want them to confuse.
Yeah.
No, there's a lot of concern about people getting confused with pills.
Yeah.
So, for obvious reasons. But I don't know, I still have trouble a little bit with the color stuff. Because we don't have that many colors. I mean, I know we have millions, but those are fine distinctions.
You have to file surveys, so it's not
Yeah.
automatic.
Yeah.
So the color orange, we have to do surveys in various cities to
Yeah.
say, when you see this color with regard to a store, what comes to mind. So
Yeah.
so you have to be using a color for a long time to be able then to successfully register the
Yeah.
mark.
We're going to talk about fame. Famous marks that really are famous, get this extra level of protection under the federal trademark laws, the Lanham Act. They get protected against dilution. So how famous is famous? Famous is Coke. I would think UNICEF. Probably some things that may be a little less famous than that. So what is dilution? It's anytime you use a famous mark in a manner that blurs or tarnishes the distinctiveness of the mark by diminishing its capacity to identify and distinguish goods or services, whether or not there's competition, whether or not anyone is confused. So dilution can occur even if a customer isn't going to be misled. I think at this point it's probably pretty safe to say that no one can call any product Coke, even if there's no chance anyone would think it's coming from the Coca-Cola company. I suspect the same would be true of UNICEF. There are probably a number of other marks that would qualify as famous. It's a determination made by courts. It's not a determination made by the trademark office. And, dilution just means another person using it, so you're not the only one using it. So I think in a lawsuit, the challenge would just be to convince the court that you're famous. I don't think you have to show much more than that. And let's talk briefly about the obligations of a trademark owner. So a trademark's private property. I mentioned before, in many corporate transactions, the single most valuable asset is the trademark. But there's also a public policy underpinning to our trademark laws because trademarks make purchasing decisions easier. They make our economy run better. And so you as a trademark owner have an obligation to police your mark. You have to be on the lookout. If you see somebody infringing, you have to do something about it. If you don't, if you tolerate a bunch of little infringers and you just think, I don't want to spend my money on that. I want to spend my money on R&D. I've got other things to spend my money on. The risk is, then somebody comes along who's an infringer and you say, that guy's bad, I'm going to stop that guy. Well, you go into court against that guy and he points out the other infringers that you didn't do anything about. And the judge says, well, I don't know, you've tolerated these other infringers. It amounts to a naked license. Who knows what they're doing? They're out using your mark. People have the potential to be confused. You don't have a trademark anymore. And believe it or not, there are some cases in which courts have reached that conclusion. Trademark owners who are trying to enforce their rights have lost their mark because there was evidence that there were other infringers that they didn't do anything about. So now that we're in the digital world, it's even sort of a more overwhelming obligation in some ways. I don't mean to say that you need to do a trademark search once a year, but you should have somebody in your company who monitors the internet, monitors social media. It's important to have rules about social media use by employees. You want to identify infringers, then you want to evaluate them. And if you think they're serious, you have to pursue them. There are trademark infringements that occur on websites, and a lot of the user-generated content websites like eBay and Facebook and things like that have policies for dealing with infringement. So if you go to the website and look at the terms and conditions, sometimes there are pretty easy ways to deal with a trademark infringement. Sometimes it's more complicated. You have a question? No. Oh, okay. And other thing to bear in mind is not every use of your mark by a third party is an infringement. If there's no other way to say something about you without using your name, it's generally okay to use your name. It may not be okay to use your logo, but it's generally okay to use your name. And that's why you often see comparative advertising, where a company will name a competitor and compare. Our product's better than so-and-so's, here's why. That's okay. I mean, I'm sure the competitor hates it, but it's legal. It's protected under the First Amendment as long as you don't say anything misleading or untrue. A lot of times courts will draw the line at logos, but I have seen logos used in comparative ads. I think it kind of makes sense to draw the line at logos, though, because logos are very potent and they register subliminally, so it can be confusing. Last but not least, when you've got a trademark, you want to think about how to use it, how to present it. If you're writing something, you probably should use it as an adjective. Krispy Kreme donuts, Apple computers, etc. We mentioned before, that's why you hear Jell-O brand gelatin and Kleenex brand facial tissues. You want to be so famous that you're like Escalator, but you really don't want to wind up with a trademark that's not a trademark. It becomes a category name. Do everything you can to keep that trademark as potent as possible, starting with choosing something that's potent. Avoid variations. And if you decide you want to develop a family of marks, which you can do, be really careful. McDonald's has done a pretty remarkable job with its McFlurry, McThis, McThat, but you can kind of run wild with that, and they haven't. They've done it exactly right. I think Target also does branding really in an extraordinary way. I think, finally, there are countries that do not recognize common law rights. So if you've got international ambitions, you have to register in every country. There are some ways to file one application, like with the CTM, and get a whole bunch of countries in Europe together. But generally speaking, you have to seek protection in each country. I think that's it. Any questions?
How do you feel about Google and becoming a
Oh,
generic
Google,
term?
I know. Because everybody says Google it.
I'm going to Google this.
Google it.
But they're using...
Yeah. Now, do you
Yeah,
think
or whatnot.
do you think they always mean use Google to
No,
look it up?
absolutely not.
They just mean look it up.
I think that's a big
That's
issue. for
scary.
Google.
No, Google's got an issue there. Yeah. Yeah.
When you talk about protecting your rights against infringers, like, and I think of Escalator and Google, like, are they supposed to come after me if I'm like, you know, if I want to paint the bottom of my shoes red and walk around, or if I want to, you know, if I work at a mall and I say, you know, put up a sign and say Escalator's broken, are they supposed to, like, for every time someone's doing that, are they supposed to, like, no?
I mean, if you paint the bottom of your shoes red, you're not manufacturing them and selling them.
Right. It's really,
No, I would say that's
commerce.
totally fine.
Right.
Yeah. And what was the other example? If you
Well,
worked at a
think about
mall?
it, for Escalator, and like,
Oh.
you know, there was no way to stem the tide of just like people using the term generically. I think Kleenex is probably on its way out too. You know, like
Maybe Google too.
Google's in everyday language, we all now use
I know.
these terms.
Well, that's
So-
the battle they're fighting.
Right. People know there's Google Plus.
Right. Mark and I were just saying, right, go ahead, Mark, and then I'll share.
With like something like Google, people recognize that there is a Google website, at least now. Maybe 20 years from now, maybe they won't. But other terms that become generic, they say Ashburn, you know, maybe never, people now don't realize that was an original brand. You know, when I first tell people that, I'm like, oh, I didn't know Bayer had that.
Right. And when a manufacturer comes out with an incredibly new product, a totally innovative product, I think then there's a higher risk that whatever they brand the product is going to end up being the name, because consumers don't have a name for that product. Like,
Right.
Even iPhone.
Yes, yes.
Well, Xerox used to put ads in the newspaper and magazines.
Yes,
And because people
photocopy.
would say Xerox this.
Yeah.
Yeah.
So the new name for Google, the parent is Alphabet.
Alphabet.
Yeah,
So can that
Is
be a
what?
trade?
it's called
Alphabet
Alphabet.
it.
That's a bad mark.
Is that a good or bad?
That's a bad mark.
It's a
I
bad
think it's a
mark?
bad mark.
They
Doesn't have any
changed the
cachet.
name officially.
Doesn't
But it doesn't have any. It
doesn't have any meaning.
doesn't have any
When
meaning.
right, but it's not being used as a mark. That's being used as a
Oh.
corporate name.
And it's
I
not
didn't
being
know
used
that.
as a trade name.
Not to.
So that way it doesn't
What-
matter.
It's being used as the name of the entity, as a trade name. I don't think it's being used to brand any service.
Yeah, but if they're not, how many people here knew that Google changed its name to Alphabet?
The corporate,
But when I,
corporate name, yeah.
The corporate name, not
Okay,
search
but-
service.
so, what does that do?
Nothing.
Nothing.
It's the name of
Yeah.
the new
It's just a
corporate
Maybe too
parent.
early.
Yes.
It's a parent.
Yes.
Well, okay, but
It's not forward facing
Yeah, it's a
to
corporate reason.
users.
yeah, the thing that really matters is what you see when you go to use the
Array of
search engine.
activities and not just the Google.
Like, right, like the driverless cars,
driverless car.
drones.
Yeah, the drone
Drones.
stuff.
Or spaceships, you know.
They did Apple.
But it is a funny name to have.
For such an innovative company.
But then they gave in because
pretty
Beatles
bad.
became available on iTunes.
Right. All right, well, thank you, everybody.